This is WPSL Port St. Lucie, the talk of the Treasure Coast.
The opinions on this program are those of the program host and guest and not necessarily those of WPSL. WPSL does not endorse products that may be mentioned. Any reproduction or retransmission of this broadcast is strictly prohibited without written consent of WPSL. Legal questions? Ask a lawyer. Give us a call at 340-1590, 340-1590 here at the studios of WPSL. And Ask a Lawyer with your host, attorney Stuart M. Address.
Good morning. I am Stuart Address, and this is Ask a Lawyer for Friday the 13th, March 2020, also a full moon. That doesn't seem surprising, given that the MLB is closed, the NBA is closed, the NHL is closed, the NFL is closed, the NCAA is closed, lots of schools are closed, universities closed, airlines cutting back, the cruise line industry essentially closed.
And as I've told my staff, forget about all my sports schedules.
Right. What is going on here?
Whew.
The market is down 25%. That's scary. Friday the 13th, scary.
Nah.
And my alma mater, Rutgers, was about to go to the NCAA tournament for the first time in 29 years. I feel for those seniors that may never get the opportunity to experience that. That has to be horrible.
New proposal. Seriously, there is a proposal out there that was offered to the NC2A last night to give, I think Mike Krzyzewski at Duke proposed to give the seniors another year.
Well, I heard something about that, and I think that would be great because, we may not be able to solve all the problems that the coronavirus is causing, but some of them, might be dealt with. And, man, if these seniors, most of them, 90% of them, 95% of them, that's the end of their basketball.
Oh, 99.
There's no NBA.
Keep going up on that.
There's no NBA. And for the seniors who have worked so hard and may have their first opportunity to get to the NCAA tournament, I feel for them. I really do. And I feel for, a lot of people. And some of this, will be better in time. Hopefully the market will be better in time. Some of it, the effects of it, we're never going to get back. And so that sort of leads us into an interesting question. Coronavirus litigation.
Sue the CDC.
They are.
Oh, come on! I was just joking.
We will get to it, but the San Antonio, Texas, is doing just that, and we will get to that. But coronavirus litigation is already underway. A lot of it. For example, the state of Missouri is suing televangelist Jim Bakker. During a February 12th broadcast of the Jim Bakker Show, he questioned a so-called health expert who claimed that a blue and silver bottle called Silver Solution was effective in preventing and treating the coronavirus. The guest said that the solution, quote, has been proven by the government that it has the ability to kill every pathogen it has ever been tested on, including SARS and HIV, end quote. The guest asserted that the solution had been tested and, quote, has been able to eliminate it within 12 hours, totally eliminates it, kills it, deactivates it, end quote. Sounds like something Trump would say.
Who the hell would believe anything on the
Well,
Jim Bakker
the
show?
price for this silver solution was $80. The Missouri Attorney General has filed suit against Bakker and the guest to stop the sales or advertising of the product. Prior to the suit, the Attorney General sent a cease and desist letter, which stated in part, quote, the 2019 novel coronavirus poses serious consequences to public health, and consumers are concerned as to how they can best protect themselves and their families. Your show's segment may mislead consumers as to the effectiveness of the Silver Solution product in protecting against the current outbreak, end quote. It is against Missouri and federal law to misrepresent the efficacy of treatments to infectious diseases. So there's a lawsuit.
I agree with the state. I mean,
So do I.
That was absurd.
Yes, and that's, snake oil salesman. So, big lawsuit here. Now, we're not done. We're just beginning.
And there's more.
2 passengers of the Princess Cruise Line's Grand Princess have already filed suit. 2 Broward County residents who are on the cruise ship have sued Princess Cruise Lines in federal court for, quote, not taking all necessary precautions to keep its passengers and crew safe, end quote. They also assert that they wouldn't have gone on the cruise if they had been advised of the, quote, actual risk exposure, end quote. And the lawsuit alleges that, quote, as a result of the Princess Cruise Line's lackadaisical approach to the safety and health of the plaintiffs, its passengers and crew aboard the Grand Princess, plaintiffs were at actual immediate risk of physical injury, end quote. And so, the 2 passengers essentially alleged the cruise line failed to put into place proper preventive measures, including more rigorous screening of those boarding the ship. And they alleged, quote, Princess Cruises had numerous occasions where they should have known they needed to have precautions in place, and they failed to act appropriately, end quote. They're suing for $1 million.
That puppy's a stretch.
No, not really.
Okay, so now wait a minute. You're going on a cruise. Are you expecting the cruise company to take your temperature as you get on board?
No. And I'm putting aside right now issues of maritime law, which impacts this. Impacts the general concept of negligence. But putting that aside now, because I really don't know maritime law, it's a negligence theory. Did they take proper reasonable precautions? Had they experienced outbreaks before of the novovirus, which we're going to get to in another lawsuit, so that they knew how to disinfect? If they didn't take proper reasonable precautions that a reasonably prudent person would have taken, that's negligence. If that negligence led to injury, there's a cause of action. Now, is it a great cause of action? Is it a stretch? Is it I don't know. I guess we're going to find out in the courts over the next 10 years. Because that's what it's going to take for all this litigation to wind through the courts.
Poor Mickey Arizona.
State and federal. Okay?
Poor
now,
Mickey.
Second Princess lawsuit.
Oh, no.
A dozen passengers of the Princess Cruise Line's Diamond Princess have hired counsel. These passengers retained a large national law firm who asserts that the company should have been familiar with necessary preventive actions from prior norovirus cases on board. There's the negligence argument in that allegation.
The word prior.
Right, so that you have viral outbreaks possible on the cruise ship. You should be taking appropriate precautions. If you're not wiping everything down before the next cruise, if you're not properly checking passengers to make sure they're not obviously or evidently sick, no, don't have to take everybody's temperature, but if somebody is getting on coughing and sneezing, and you may want to check that person. So if you're not doing that, are you negligent? Or are you just careless? That's a legal battle that's going to be had.
Well, Carol and I had an interesting experience the other day picking up a check for the Christmas kids at the hospital.
Okay.
And
was it one of those big checks?
No, not a big check, but it was, check from the Pink Ladies at the gift shop who donate every year. And we were met by 2 nurses in hazmat outfits outside the hospital. And the first one had a list of questions, and if she was sufficiently pleased with your answers, you moved on to the next one who took your temperature.
See, that sounds reasonably prudent.
And now this is outside the hospital. This is not even in the doors yet. Lady in front of me was running a fever. And she said, "You're going to visit someone in the hospital?" And she said, "Yes." And
She said, "No, you're not."
She said, "Why don't you come back in a couple days?" And I thought, wow. And then, of course, I just whizzed in. But, it was like, wow. I just, all of a sudden,
it is changing
real.
Our environment. And
yes,
by the way,
it
folks,
is.
call us at 340-1590. Oh, I just mentioned the number, and I guess here's a call. That's this topic. Anything you want to call about, obviously. We have Curtis on line 1. Hello, Curtis.
Hello.
How can I help you?
Yes. About 9 months ago, I had a work done on my house to do a back porch.
Yup.
And they haven't finished it. I've got about 2/3 of the money into the back porch, and they haven't been on the property in over 90 days. I believe that constitutes that they've abandoned the job, and since then, I believe the permit has expired on the job. How's the best way to get my money back from these people?
Good question. I've actually had a lot of these calls over the last several years. Curtis has asked, he's having work done on his home. The contractor hasn't come by in 90 days. It's 2/3 into the project. He believes they've abandoned the job. Permit's expired. How does he get his money back? Well, first thing I would do is make sure you have something in writing to the contractor, basically saying, "You're not here. I've tried to get in touch with you. This is how I've tried to get in touch with you. I'm declaring a material breach of the contract." You don't have to use magic words, but those are the magic words. It's not really abandonment. It's a material breach of the contract. Have you already hired somebody else to finish?
No.
All right. You probably, I don't know, during the 90 days, have you been talking to them, trying to contact them?
Yes. In fact, I put in a call Monday morning, and the person was in a meeting and said that they'd get back with me.
Do you have anything in writing that you've been contacting them? Have you sent any emails or letters?
I sent a text.
Okay, good.
I called, and he responded back with a text.
Okay, well, that's helpful. Because what I would want to see as an attorney, if you were calling me, is I'd want to see at least some communication, one way or the other, indicating your effort to get them back and basically their refusal to do it. Because then I would say to you, declare a material breach, hire another contractor, let the other contractor finish the job, and then if the other contractor, let's say you have another $5,000 to go on the project, but the other contractor charges you $7,000 to finish it, well, your loss is $2,000. And I would say the original contractor is legally responsible for that, because you're making an effort to mitigate your damages by getting another contractor to finish the job instead of leaving it open, which could, damage it.
Okay, at this point, I would like to get my money back and them to, the job was to finish a back porch, to install new windows, close it up. I would like, and I'm not happy with quality of work. It wasn't what I expected. I would like to get my money back, and then once I get a check for that amount, let them come and rip out their work.
Well, that's a slightly dicier question. Now, if the quality is not what was contracted for, you're certainly entitled to get what you bargained for. But if you just generally wanted them to, rip out the project because they didn't finish it, it's unfortunate. That's not the way the law works. You're not entitled just to your money back because they breached. You're entitled to the damages you suffer. So really that is traditionally measured by the cost of getting somebody else to finish the job, and if that cost is higher than what you owed the original contractor, those are your damages. Now, if the quality is substandard, there is damage there too. if they installed a window that should have cost $500 and they got $500 from you, but it's really only $300 of value, and you get the new contractor to replace those windows, yes, you can return those old windows to the original contractor, and I think you're entitled to that money back. But to rip something out that may not need to be ripped out, that another contractor can just complete, that would not be consistent with contract law.
Okay.
So I definitely get something in writing to them, text, email, whatever, that you've been making efforts. If they don't contact you, within 48 hours, you're declaring a material breach, and you're going to mitigate your damages by getting another contractor to finish, and you're going to hold them responsible.
All right.
That's
Okay.
what I would do. And then if you have more problems, then you need a lawyer.
Stuart, should he be taking pictures along the way?
Oh,
too?
goodness gracious, yes. Absolutely, positively. Pictures, video. Lawyers love the more evidence you can give us, the better.
Okay. And if I had to get a lawyer at this time, and I went to court or whatever, would I be able to recoup everything, or do I pay a lawyer per hour and part of the settlement?
No, you wouldn't pay per hour and part of the settlement. You'd pay either or. But as to whether you could recoup it, was there an actual contract for this job?
Yes.
I have a funny feeling that buried in the fine print of that contract is an attorney's fees provision. Now, it may not say, whoever has to sue the other can recover their fees. It may be written in a way that seems like only the contractor can recover his fees, if you don't pay him. But whenever there is an attorney's fees provision in a contract, even if it reads one way, by law, it's mutual. So you probably would be able to recover attorney's fees, legally speaking.
Uh-huh. Okay. So it's either or.
Yeah, no attorney's going to charge you an hourly and a contingency. Otherwise, I suggest you take them to the Florida bar.
Okay. Well, thank you for your information.
You're very welcome, Curtis. Thank you for listening. Thank you for calling.
Thank you.
Bye-bye.
Bye.
Yeah, I do get a lot of these calls.
Really?
And by the way,
Wow.
if Curtis is still listening, you can also file a complaint with the Department of Business and Professional Regulation and put that contractor's license at stake. Very often when they get a letter from the DBPR, the contractor all of a sudden is very willing to finish the job.
Oh, yeah.
I'm sorry I forgot to tell them that on the
Folks
call.
in Tallahassee, yeah. Oh, yeah.
And, unlike a lot of agencies, they actually do respond. And I had a client where the contractor did lose their license.
Really?
Yeah.
Wow.
So it happens.
Do you get a lot of, I've seen them on television, like swimming pool type?
I haven't received swimming pool calls. A lot of porches and extensions, and refurbishings, a lot of things like that.
Interesting, huh?
And do we have another?
Yes, we do.
Yes, we have another. Nobody wants to hear about the coronavirus. We have Richard on line 3. Hello, Richard. How can I help you?
Hi. I purchased a vehicle from a local dealership and received notice that it has a safety recall. And it states that the cable from the transmission could become detached and the vehicle could crash. And there is no engineering fix for it at this time. They haven't offered any remedies, but I looked at the Florida lemon law and saw what my options are. But they're still selling the vehicle, and NHTSA says you can't sell a vehicle that has a safety recall.
Well, I'm not that familiar with all those regulations, I'll be honest with you. I would think you could sell a vehicle with a safety recall as long as there's a remedy for the recall. Now, you're saying that they don't have a remedy for this.
Correct.
So I would think as a matter, again, we're talking negligence here. As a matter of negligence law, they better stop selling the vehicle because they're going to be responsible.
That's what the statute says.
Well, and I'm not even talking statute right now. I'm talking common law negligence tort action. Because they're going to be responsible, in my argument, for any crashes, accidents, injuries that are caused if they know there's a safety defect, there's no cure, and they continue selling the vehicle. Now, in
Well, that's
your
what the law says. It says civilly they could be responsible, and
Right.
criminally if there's harm done to an individual because of it.
and in this situation, in addition to common law negligence, you're right. There is a statute, and so the statute provides what the duty is, and additional remedies. You know, anybody in this situation could sue under the statute and under common law negligence. Now,
What about my opportunity to
Right.
use a vehicle now? Because
Okay.
if they're saying there's a safety issue involved, that they have to provide me a rental car or something in the interim until the fix is made.
I would think so. Really, I would believe that if there is a fix, if there is no fix, first of all, I would be using, as you say, the lemon law statute, and you'd have to follow it very precisely. I mean, I've dealt with the lemon law. It's not at the top of my head right now, but I think you have to give them 3 attempts to fix it,
Right.
or it has to be in the shop and out of commission for a certain period of
15 days.
time, and then you have to follow the manufacturer's, lemon law process if they have one, and they all do. And then if you don't like the outcome of that, you can actually file suit in civil courts. But yes, I would absolutely believe that if there is a vehicle that has a serious safety defect and there is no present cure for it, that there's a material breach of the contract and that vehicle should be returned. And
Well,
you
they
should
say
get
there's
a new vehicle.
220,000 vehicles with this
Right.
defect.
Well, that's a
And no
serious
engineering
problem.
fix.
Serious problem, but they still have to find a way to appropriately deal with it somehow.
Have you dealt with this dealership before?
Yeah, they've always been reputable. I mean, it's not their fault. It's the manufacturer.
Let me tell you something. In
Crazy.
products liability, the plaintiffs
sorry?
sue in products liability cases. The plaintiffs sue everybody who sold it to them, who supplied it, who manufactured it. Everybody in the line of commerce gets sued.
Well, it says NHTSA says it's their obligation to bring the legal action forth against the manufacturer on behalf of the consumer, but it doesn't say what the direct effect to the consumer is for immediate relief.
Right. Well, I would think NHTSA's looking at the big picture. You're looking at your picture, and
Right.
I think you should be demanding that either the vehicle be repaired, or if not repaired, replaced, and not replaced with the same vehicle because they all have the defect. Replaced with another vehicle of your choice that is the same value.
Okay, well, thank you for your information.
You're welcome. And if it doesn't work, then again, that's when you really need to call and get a consultation with an attorney, whether
Thank
it's
you,
me
sir.
or somebody else.
Yeah, if you know your dealership or know your salesperson, have them move you out of that car.
Yeah, right now I'm
Well-
dealing with Toyota of Stewart on a
It's
issue.
a motorhome,
Okay.
so it's a
It's
pretty
a
expensive
motorhome.
item.
Oh, God. Oh, man. Good luck.
All right. Hope it
Thanks.
works out for you.
Bye-bye.
Bye-bye. All right. So these
Wow.
things, yeah, I have not really heard of a safety problem that can't be fixed, but if that's the case, I would think all those vehicles have to be returned.
250,000 vehicles.
Yeah.
I mean, come on. How? I just don't even understand how that thing could still be on the market.
They'll have a fix to it really soon. People are working really hard right now.
I would hope so. Man, that's
Yeah,
ridiculous.
it is. So now,
Want to buy a cruise ship? We got one on sale for
let me tell you,
SwapShop.
we also have American Airlines being sued
Ooh.
by the pilots union.
Okay. No, I can see that.
The union has sued
I
the
can see
company
that.
to stop service to China.
Yep.
Okay, that makes sense, doesn't it?
No, yeah, because they have to lay over there.
So if the company won't do it, then, the union files a lawsuit. Who else is sued? Costa Mesa, California,
Hey.
has sued the U.S. government.
Okay.
They have sued the government to halt the transfer of quarantined cruise passengers to a state-owned facility.
Oh, yeah, it's right. Yeah, it's right near the big mall there.
Now, the problem, as I've read in this lawsuit, is the state is going along with the federal government's desire. The city is a subdivision of the state. So the city cannot say, well, we disagree with the state and we're suing you. If the state isn't going along with the city's desires, I don't think the city has standing. But Hey, that's just my opinion.
Our old house in San Diego is about 5 miles from Miramar Naval Air Station. And they're going to be housing a bunch of the people there. Oh, man.
So what has happened in San Antonio, Texas, other than people coming over a make-believe wall? Ba-dum-bum.
They're putting a wall around the canal there.
Maybe they should wall in all the people with coronavirus. I don't know.
No, don't even go there.
You might like
I think
that.
they did that in World War II,
Yeah.
didn't they? Yeah.
All right, well, the city of San Antonio is suing the U.S. HHS Secretary, Health and Human Services, and others. The city has sued based upon the government's quarantine of a cruise passenger after she had been cleared by 2 tests for the coronavirus. She left, and a 3rd test came back positive. The city now demands that passengers undergo 3 tests instead of the current protocol of 2. And the city has also sued the CDC, Centers for Disease Control, the Justice Department, as well as HHS, to prevent further release of individuals who have been quarantined at Lackland Air Force Base.
Yeah. That's where I had basic training.
They don't want them released.
Yeah.
Until further notice. So, you see everybody's getting into the act right now. We have cruise passengers, we have cities, we have pilots unions, all ready. And this thing was basically just started in February. We're now in the middle of March, 4 to 6 weeks, and the lawsuits are already going full force.
And how about that clown who was flying on JetBlue knowing that he had it and flew into West Palm?
He probably doesn't have assets, but yes, there's some liability there.
Yeah, a friend of mine was one of the flight attendants on that flight.
Well,
she's not a happy camper
I wouldn't be
today.
happy either. Now, so let's ask an interesting question. Can you sue the government over quarantine issues or other impacts? Well, as with everything in the law, the answer is probably sometimes. The question is whether your particular issue is something that is a legitimate basis for a suit. Now, you may have impact, but as I used to tell my father when I finally became a lawyer, and now also my father's sending me all these little issues he's having, and sometimes I'd write letters and we'd get a result, and sometimes I'd finally have to say, Dad, just because you have been wronged does not mean there's a remedy to every wrong. Some wrongs are just not against the law. So it depends. Now, a lot of the issue is we have to recognize that whether you're dealing with the state or the federal government, and remember these two, a lot of people, this is part of our Constitution, and unfortunately too many don't know, but the federal government is a sovereign, okay? It's like the king. You cannot sue the king unless the king consents to be sued. Now, the federal government has
Wait a minute, back up.
That's
What?
common law England. You cannot sue the king unless the king agrees to be sued. So you cannot sue the United States unless the United States has consent to be sued. Now, the United States has a sovereign immunity statute which indicates when it consents to be sued. And it's pretty broad. States have sovereign immunity statutes.
It would never consent to be sued.
Oh no, it does. As a matter of its relationship to the people. Remember, in this country, it is of the people, by the people, for the people. So the Constitution and the U.S. Code has a sovereign immunity statute which is very broad, that allows the government, essentially under common law England terms, the king, to be sued. The same thing goes in the states. All states have sovereign immunity statutes, some broader than others. In Florida, we have a sovereign immunity statute which indicates under what circumstances you can sue the state or its political subdivisions, how long you have to sue them, what notice you have to give prior to filing a lawsuit, how much they're liable for unless the legislature agrees to a higher amount in your situation. And it caps the attorney's fees at 25%. If you want to sue the sovereign, you've got to follow the rules. So what I'm saying here is, what we need to recognize is there are two sovereigns. The federal government is a sovereign. The state government is a sovereign. Okay? You can only sue either of them under certain circumstances. Oh, I'm sorry. And we abate that discussion of sovereign immunity. Fascinating discussion. I'm sure you are all sitting there with your Cheerios halfway between the bowl into your mouth.
Simply riveted.
Because we have Russ on line 3. Hello, Russ. How can I help you?
I'd just like to let you know that it's a three-quarter moon, not a full moon.
Oh, really?
We'd hate to have you liable for that.
Oh.
It's a waning moon, almost three-quarters.
Well, I Googled it, and it said there was a full moon. Now, when you Google something, who do you sue? Is it Google? Is it the internet?
Isn't that your responsibility?
I don't know.
Hey, Russ, I'd go after him on that.
Well,
That sounds like slander to me.
If you sue me, I'm going to sue Google. How's that?
That'll work.
Well, thank you for the corrective information on the waning of the moon. I appreciate it. Okay, I guess that was all Russ wanted to indicate.
Oh, that's funny.
Hey, look, all I know is that the Google did say it was a full moon.
All right.
Now, if Russ is wrong, Russ, I'm going to come and get you.
Now, the ultimate resource is right next to you.
I used it.
What would Siri say?
Oh, we don't want to do that on the air. We can do that afterwards. All right, so what we have to understand is whether we're dealing with the state or the federal government. Governments have broad authority when it comes to issues of public health. And there's every good reason for that. So to sue either government when it's an issue of public health, which is the coronavirus, it's going to be very narrow circumstances under which they can be sued. Now, what you have to allege if you're going to try to make a lawsuit like this is that the government did not properly and reasonably balance the interest it has in protecting public health against the interests of individual rights. And you're going to have a hard road to show that they didn't reasonably consider the balance. Maybe some of the things are too broad, but looking back 2020 won't work. Is it not reasonable now? When Governor Cuomo says no gatherings more than 500 people, and I think it's Governor Inslee in Washington says 250.
Yeah.
Well, is 500 too much if Washington says 250? No, they're probably both okay. The governors are acting within their sovereign authority to protect public health and doing what they believe is appropriate based upon, I assume, communication with, good authorities. And if that's what they're doing, they're going to be protected.
When would you think that you'd see Broadway plays shut down?
That's another thing I was going to mention. There has been discussion, can these producers sue the state? I don't really think so, honestly.
No.
I think, that, and the Broadway shows didn't close down because the governor said close down. The Broadway shows closed down because the governor said you can only be at 50% capacity. So they can only make half the money for each show, each run. And the producers decided they can't make money, they'll lose money if they can only have half an audience at each show. So Broadway has shut down. Now, that is a decision of the producers. I understand the decision. Economically, it's not a bad business decision. It impacts a lot of people. But the issue is, is Governor Cuomo going beyond his authority, or Mayor de Blasio going beyond the authority in making these decisions? The 1 mile containment zone around New Rochelle, should it be 5 miles?
Build a wall.
Should it be 1/10 of a mile? I don't think litigation like that is going to go anywhere because of the powers that governments have to protect public health.
That just seems like you're splitting hairs if you were doing something like that.
But if you do have a situation where you can make a clear argument that a reaction taken unfairly impinged upon individual rights, notwithstanding the public health issues, then you may have a claim. Now, by the way, and we talked about the 250 and the 500. I don't know who it is here, but there is some place where the restriction is 1,000 people. So is the 250 too little? Can they be sued? Is 1,000 too much? We see that the lawsuits are already starting. I'm telling you, these are going to be lawsuits that are coming.
But they know their local areas, though.
That I agree with you. So, if the numbers are not arbitrary, and I really do believe they're not arbitrary. I assume that during discussions with CDC, local health departments, I don't believe anybody's acting arbitrarily right now, except for maybe the person in the big White House. But
I mean, you look at the state of Washington, for instance. I mean, last week, University of Washington just killed classes, as did Seattle University.
And my son was about to leave in a week to New York City.
Oh, boy.
With the LPA ban.
Yeah.
And I'll be honest with you, it got canceled on Thursday. And on Wednesday, I had sent an email to the principal basically saying, we need a decision for lots of reasons. One of which is I was planning a vacation, and I needed to know whether my kid was going to be in New York so I can be away, or I wouldn't have coverage for him. I need to be back. But that's the least of the reasons. I had concerns about New York City in particular. This is before everything closed. But New York City in particular, they're going to Times Square, they're going to Phantom of the Opera, they're going to Little Italy, Chinatown, the Statue of Liberty. And, I grew up in that area. I'm thinking, anybody next to them
huge crowds.
Could be from Italy,
huge
could be from
crowds.
Anywhere.
Yeah.
Any person, any stranger standing next to them. I was concerned. And I was seriously considering whether to pull him from that trip, even if the school decided it was going forward with it. And last week, it wasn't so clear that it would be canceled. But I was already having misgivings, and I was hoping that the bad guy would be the school so that I didn't have to say, well, they're going, but you can't go. Because it's a trip of a lifetime. I grew up there. It was a wonderful itinerary. I so much wanted him to see this and enjoy this and understand this, go to Ellis Island, go to the Statue of Liberty. But I feared for him, and honestly, we're hearing this a lot more now. I feared for myself. Because if he contracted it in New York, he's 16. He'd probably have the flu essentially, and that's that. But if he came home and gave it to me, I'm a few months away from 60, and I do have underlying health issues. That could be my life. Parents are considering this issue. Grandparents are worrying about these issues. Not so much that the kids get it, school closings. What if the kids get it and they bring it home?
Sure.
That could be deadly. And so a lot of people say, you shouldn't be closing the schools. No, it's horrible, I agree. But these are probably prudent decisions because it's not just the kids that are at issue. You have another population of who the kids come home to and who the kids interact with, who may be more subject to the fatal aspects of the coronavirus.
What's very interesting, and Palm Beach has got some decisions to make about the election.
And I've thought about, too, you cannot postpone the election.
Yeah, but where Palm Beach has got some interesting decisions is apparently they've already had spring break or the following week, not next week. And the kids are going to be going back to school in those same rooms where the voters were.
Right. Well, they would be disinfected as soon
as
they go back to school.
I get it.
But I don't think they're going back to school right now.
There are some parents that, we're not.
But you have a lot of poll workers that are calling in saying, I'm not doing it.
Oh, yeah, I'll bet.
And you have a lot of probably polling sites that will have to be collapsed into other polling sites. turnout will be down, no doubt. It is a shame. It's more than a shame. The most fundamental aspect of our democracy is the ability to vote. And this pandemic is going to impact that. And there's really nothing we can do about it because you can't postpone the primary. You can't postpone the election. Somehow you have to do the best you can. And that's what everybody's going to do.
Just postpone the general election for a couple of years.
That's right.
Yeah.
I know somebody who might agree with that. All right. So now, where else are likely lawsuits coming from? Hospitals being sued. Restaurants.
Wait a minute. Back up. Hospitals? Why?
What if they let in that person that had that cough and the fever that you talked about? And what if that person gave the coronavirus to 10 people? You don't think the hospital may have liability for negligence? And even if they don't, you don't think that would stay in the court for years? And if there are 1,000 of those suits, yeah, hospitals are going to be sued. I guarantee you. Restaurants are going to be sued. Daycare centers. Nursing homes. Airlines, cruise lines, hotels. They're all going to be sued. Some of them already have been, as we've discussed. More is coming. There are already attorneys, not me. There are already attorneys who have taken out big ads. If you Google it, have you been injured by the coronavirus?
Oh, no.
To me, I'm sorry, they are the scuzziest of ambulance chasers.
That's got to be the guys either in Houston or in Phoenix.
I mean,
yeah,
to already, while we're in the middle of this outbreak, not even in the middle, maybe in the early stage, to have these ads out, do they do a public service in letting you know where you can get legal services? I guess in the most basic sense they do. But, man, oh, man, if somebody has a problem, they're going to call somebody. You don't have to advertise. It's not like anybody is now an expert in litigation over the coronavirus. Nobody yet has expertise. So to be advertising that we handle the coronavirus, I can advertise that. I can take a billboard out on US 1 right now. Do you need representation for the coronavirus? But, man, oh, man. That would be, to me, that would be beneath.
It's so sleazy. It's so sleazy.
Gives me the heebie-jeebies.
Yeah.
But the suits are coming. The suits are going to come by customers, by residents, by visitors. They're all going to be suing.
Can I sue for lack of toilet paper?
Maybe.
Have you seen the stores?
Well, if you go to a restaurant and they have, restrooms, and there's no toilet paper in there.
Oh, come on.
Come on. I think that they either, they have an obligation to reasonably stock the facilities with the necessary items. I don't know. It sounds silly, but maybe. Now, a lot of these lawsuits are going to be silly. They're going to be frivolous. I know there's a big segment out there that's already gearing up for the frivolous and tort reform. And a lot of these lawsuits will be frivolous. But some of them won't. Okay? A city concerned about releasing quarantined people before it's safe. Maybe they lose a lawsuit, but it's not frivolous. Cruise passengers suing, maybe they do lose the lawsuit, but it's not frivolous. Okay? People who might sue the nursing home in Washington, that's not going to be frivolous.
No.
Because I guarantee they weren't taking proper precautions.
Yeah.
There's a lot of litigation that will not be frivolous.
And I believe me, I back the pilots union too.
Yeah.
Pilots and flight attendants,
What about suits by workers under workers' compensation statutes? They got ill at work. What about under OSHA, the Occupational Safe and Health Administration, for safe work sites?
Oh, wow. I didn't think
No,
about
you're
that.
not disinfecting properly.
Yeah.
What about OSHA litigation?
Well, it's just like us here. I mean, the National Association of Broadcasters sent something out to Carol, and right away got rid of some stuff.
But by the way, folks, if you're watching on Facebook Live, you see this black microphone I have in front of me? If you go back to prior episodes, you'll see it's usually red. Well, the red is a cover. They have removed the covers from the microphones here because they easily harbor germs.
Yep.
These are easier to fix.
You can Lysol these every day. Yep.
So the National Association of Broadcasters has recommended this action. It's a reasonable action, and so my microphone is no longer red; it's black. Okay, seems like a little simple thing, but it may save somebody from getting the virus.
You never know. You never know.
Now, I think there are probably going to be lawsuits, causes of action. We talked about negligence, invasion of privacy, discrimination, unfair labor practices.
How about imprisonment?
I have read articles about the possibility of prisoner litigation under Section 1983 of the Civil Rights Act, which I do. And the theory of the litigation would be that the jails are not taking reasonable steps to protect the inmates from the transmission of the virus. Now, that doesn't mean you let all the inmates go, but it may mean more disinfecting. It may mean more separating general population. It may mean only letting out one cell block for rec time instead of 4 cell blocks. And the problem, though, with the 1983 litigation, and we only have a little bit of time, when you sue under 1983, there's a requirement that the person, the entity that is being sued, know that the acts they are engaging in is a violation of constitutional rights. And until a circuit court declares something in action a violation of constitutional rights, you have no legal basis to sue under it. But that's the chicken and the egg, because how can the circuit court declare it's a violation unless you sue under it? But if they haven't declared it, your lawsuit will be dismissed. This is federal court litigation, folks.
Whoa.
This is 1983 litigation. This is the catch-22 that lawyers get frustrated over.
Wait a minute, 1983.
Civil Rights Act.
Okay. And how long would it take to get a lawsuit like that through the courts? Another 20 years,
Well, through the courts, it could be filed in an instant. Maybe some have been filed. The first thing, the state's going to be doing is filing a motion to dismiss. They're also going to be arguing qualified immunity, which is beyond the scope for right now. But, I do want to, sort of finish up with the idea here. What about insurance coverage? Do businesses and other people have insurance coverage for the loss of time at work or the lost business? There's going to be a lot of insurance litigation because businesses and employers are going to argue they have coverage. And I guarantee you the insurance companies will defend with what's called an act of God or a force majeure defense, which is you have no coverage because the policy excludes acts of God. And the argument will be the pandemic is an act of God. It's not something that's foreseeable, therefore you have no coverage. And there will be litigation over that. I absolutely guarantee it's going to be a big area of insurance litigation. What about people who have taken out insurance for trips, cruises, whatever?
Oh,
You have insurance for it. So, okay, now, your cruise line is actually still running, but you're not going. So you want your money back because you paid for insurance. Nope, you're not getting it.
Why?
Wait
a minute.
Because most those insurance policies don't cover illness other than your illness. The fact that you're afraid of becoming ill is not a covered event.
Ooh.
Now, there is an exception. If you have paid extra, which virtually nobody does, for the all risks coverage, all risks, that means you'll get your money back.
Wow.
But the standard policy won't cover it. And by the way, as to whether or not the coronavirus or any pandemic constitutes an act of God, there's no judicial precedent on that yet. That's why we're going to have tons of litigation. And we're going to have different decisions throughout different states and different federal circuits. And ultimately, one day, the Supreme Court will have to make a decision on the federal level as to whether a pandemic constitutes an act of God. I guarantee in 10, 15 years, whatever, the court will make that a decision on that issue.
Wow.
Okay? Can you sue your employer over missed work and pay? Probably not.
I feel sorry for the daily hires at
Yeah.
work at stadiums and
Now, if you work for Mark Cuban, the owner of the
wonderful.
Dallas Mavericks, who has promised to pay all his workers
That was
out of his
nice.
own pocket,
That was nice.
and hope that other owners of NBA franchises will feel guilted
Fat
to
chance.
follow his lead. But no, if you can't work because the restaurant's closing down, no, you can't get the money from you. That is the problem of why they haven't used the official word yet, because it takes 2 consecutive quarters of negative growth. Boy, isn't that interesting on the radio?
Recession.
But we're in a recession. The market's down 25%.
Bull market.
People aren't going on cruises. People aren't flying. People aren't taking vacations. People aren't going to restaurants. People aren't doing this and that. And that. People are not spending money. People are afraid to spend money. We are in a recession. And no, you can't recover money just because the economy's in a recession. So, as we have a minute or so left, I did get through my discussion that I wanted to today, which is amazing, of the coronavirus and just the tip of the iceberg as to litigation that is already underway and litigation that's sure to come. I hope all of you keep safe, stay healthy, have a good weekend and a good week, and I will be back, I hope, next Friday, and we'll talk about something else legal. In the meantime, this is Stuart address for Ask a Lawyer, and if you need to call my office, it's 772-781-8003. Sadia is standing by to accept your calls. Have a good day, everybody.
Oh, you can pick up the 6-pack of Corona that I have on the floor for you.
Yes, Corona. Yes.
This is WPSL, Port St. Lucie, WSTU. Stuart.